Hello, everybody. Good morning, good afternoon. My name is Leon Castellanos-Jankowicz, and I'm the academic coordinator of the Netherlands Network for Human Rights Research. And it is my pleasure to be here with a stellar cast of characters who are going to discuss a very interesting case with us here today. I would like to introduce you first to our speakers who are here with me, Jolein Holtz and Anmol Gulecha, as well as my colleague Eva Romanowska, who is the intern for the Netherlands Network here at the Asser Institute for International and European Law in The Hague. To come back to our guest speakers today, who are also members of the Netherlands Network, both of them are PhD members of the Netherlands Network, and if you have not joined yet, you should definitely click on the button below, check us out, and send us a message, especially if you do your PhD in the Netherlands and are working on human rights related topics. So Jolein Holtz is a PhD candidate at the Leiden University, where she works at the Grotius Center for International Law. And her PhD is about collective human rights and climate change. Jolein is in her fourth year of the PhD, so nearing the end. And Jolein, it's very nice to have you here. Thank you for coming.
Thank you for inviting me.
Pleasure. And here to my immediate left is Anmol Gulecha. Anmol, you are doing a PhD as well in Tilburg University on protecting human rights through judicial policymaking, which is another fascinating topic, and you're in your third year of the PhD trajectory. So welcome to the Asser Institute.
Thank you for having me.
Thank you for coming. And of course, our intern, Eva Romanowska, who is currently completing her bachelor's studies in the Hague University of Applied Sciences. And thank you, Eva, for helping us set this up. And with this, I would like to give you the floor so that you can ask the first question about the case we're talking about. And that is the very famous and already iconic, I think, case of Duarte Agostinho and Others versus Portugal and 32 other states. So this is the very famous climate litigation that is ongoing in the European Court of Human Rights, and it's the topic of our chat. Eva, please go ahead.
Before we begin, Anmol, maybe you could briefly summarize the facts and the backgrounds of the Duarte case for us.
Yeah, sure. So this case was filed by 6 young people from Portugal, and it's filed against with the European Court of Human Rights. It's filed against 32 member states of the Council of Europe, and it was filed in 2020. The main claim, or like the main facts, are that they are arguing that the states are not doing enough to reduce the greenhouse gas emissions to achieve the targets in the Paris Agreement. And right now, the case is yet to be decided on merits, but there's a lot we can look forward to. And the background is obviously that they are from Portugal, and Portugal has been seeing a lot of forest fires, heat waves, which is also which is a resultant of climate change. So they really want to tackle this issue of climate change through the courts. Do you want to build on this?
No, I think that's okay. a good summary. I think we'll go into depth a bit more later. So yeah.
Great, thank you. And could you tell us about? I mean, that is really the background being a group of young people, as we've seen in many other cases of strategic litigation for climate justice, right? It's really young people who are driving this and pushing this. So I think that's something that is important to keep in mind. And, you know, moving on to the reasons why they're bringing this case to the court, Jolein, could you please tell us about the grounds of the complaint that they're invoking and the kinds of claims that they're making?
Yeah, sure. So what we see at the European Court of Human Rights generally when we're talking about environmental issues, which of course climate change is one very pressing issue of, is that oftentimes they invoke Articles 2 and 8, which means the right to life and the right to family and private life, and which is similarly true for this case. But as you mentioned, it's also a case brought by young people, who are facing the brunt of climate change and who are also put forward or calling themselves the voice for future generations, which is a very important topic when we're talking about climate change, but also sustainable development as sort of an overarching concept. So they combine these claims on Articles 2 and 8, so privacy, life, and the right to life, with the prohibition on discrimination, Article 14, to really position themselves as separate from the masses because they are young people and they are in this particular vulnerable situation. And this is then similarly linked to the right to life and the right to private life. So there they are stating how for young people, but also the generations yet unborn, you have all these specific related risks. And then very interestingly, and sometimes an overlooked point, is that they also look at the prohibition of ill treatment in Article 3. And here it also really much focused on the psychological effects that it's having on the youth. And as a climate researcher myself, I definitely get this point too. It is such a heavy topic. And it seems it's so out of reach in a way. So they're also saying, the mental aspects that come with it, the climate anxiety that you hear a lot about, that this could amount to a violation of the prohibition of ill treatment. So it's these 4 articles together that they are invoking.
Great, thanks, Jolein. That's very clear, and it's interesting how the very different dimensions of how climate change can affect the livelihoods of people in general, but especially young people, are being put forward here. And we can, recall the submissions that Greta Thunberg and other young people made to the right instruments relating to the Convention on the Rights of the Child in the UN treaty bodies and so on. So again, just sort of going into that trajectory. Eva, I think you have the next question.
So you have mentioned already now that there is a rise of strategic litigation when it comes to environmental law, and also the fact that you, Anmol, mentioned that the case is brought by a group of youth climates. So how is this case different from other strategic litigation cases? Is there something else that is very unique about it?
Yeah, that's actually a very good question, because first, this is the case that's brought by young people. And this is one of the first cases brought by young people with regard to tackling climate change, because like Jolein mentioned, that they are the ones facing the brunt of it, and they have to face the brunt of it in the future as well for a longer time. So that's one unique aspect. And the second one, what we see from other climate change cases, is this is going to apply throughout Europe and the Council of Europe, amongst all the states. Which I think is also quite innovative, because they are going beyond the jurisdiction of just Portugal, which is their home state. And for that, they rely on, if I've understood correctly, they relied on shared responsibility, because it's not only one state that is responsible for climate change, but it's all of them collectively are responsible, and they have to take collective action to reduce their reduce their emissions, which I found quite different from the other strategic climate change cases that have been litigated all around the world right now. Would you like to add?
Yeah, I think in a way, because we call, of course, this strategic litigation, and it is because it can have such a wide effect if you define it in that way, but it also, in another sense, makes it's very logical, because you have, the climate science has gone so far that they can quite specifically retrace the emissions, and we know who has caused the most of the emissions. So anyone under the jurisdiction of the courts, it's actually in a way makes more sense than just going to one state, because the emissions are shared. So the character of climate change, its specific scope, is more well suited for a case like this. So it also makes a lot of sense. Yeah. So it's not just that you're like, oh my god, this is a very legal innovation. It's in a way that the problem of climate change requires an action like this as well.
Right, and that is I think what makes the case special. Definitely, as a sort of it gives it an added value, and it distinguishes it from other initiatives. And if we drill down on this point a little bit, the claimants are from Portugal, but they sue, right, the states in the Council of Europe plus some other states on the European continent. So how do they go about asserting the jurisdiction of the court when it comes to the claims that are made against those other states? Could you say a little bit about that extraterritorial sort of dimension of the case?
A lot of it has to do as well with how their specific status, so also it's related to victim status too, is related to these other countries. Because in human rights law, it's still a very much individual versus their own state-based system. But of course, when people would hear it, it will sound strange that there's people in Portugal going through all of these states, these sort of powerhouses in a way. But what they are saying is, of course, all of these states together, and what I mentioned, are responsible for the effects that they are feeling. And the effects that they are feeling are unique as youth, from what I've said as well. And then they're holding, okay, we have to go to the European Court first of all, because then they can, combine all of these states. That's what you can do European Court. Of course, you can't do that in front of your domestic court. And also, if you have to do the domestic procedures, which the exhaustion of domestic remedies is a requirement for admissibility, that would take a lot of time. And we know now, and when we see a lot of more like scientific journal articles coming out, that we're getting very close also to some tipping points. So when we're talking about precaution and about real and immediate risk, which we might get into a bit later on, they're saying it will be completely unreasonable if we have to go to the Portuguese state first, and then even if we go there and we have a successful case, it's just Portugal, right? And there's much more emissions in other states going on.
Thank you. Yes, so you have mentioned here an interesting point that they have not exhausted domestic remedies in their home state, Portugal. So how do you think this claim will go through? Do you think it is going to be successful before the court?
So like Eva mentioned about the immediate risk, so there in their application they also mentioned that there is an immediate risk of climate change. So even though there is an admissibility requirement under the European Convention that you need to exhaust all domestic remedies, they categorically state that the climate emergency is such an immediate risk that exhausting domestic remedies in all 33 states was going to take time. You don't know how long, you don't know the outcome, and the outcome must be similar in all 33 states, which will take time, and then we will reach we'll probably go beyond the tipping point. So they are saying that to protect their rights as the youth and as children, that there needs to be immediate action. And interestingly, they rely on the Convention of Rights of the Child, where they state that children are also vulnerable to this and there needs to be an immediate action. So I think it's interesting that they go to the European court, and also it's interesting to see how the court will then have a causal link between the immediate risk and also not exhausting domestic remedies.
I think in relation to the point you made about the Convention of the Rights of the Child, actually the European Court is the most self-referential court there is. You see in UN institutions, but also other regional courts, that they tend to reference other jurisdictions. The European Court does not. And of course, the Convention of the Right of the Child, I think it's the most ratified, or together with civil and political rights covenants. So it would be great if they would take it on board. In practice, it will. I'm curious, but also we have, and Leon mentioned this, the Sachi case that was in front of the Committee on the Rights of the Child, where they actually deemed it inadmissible. Also similar reasons, but then they went into the victim status, I think a little bit like we did in this discussion, by sort of opening the doors and saying causality is probably there, which was an interesting point of that case. But of course, if the European Court chooses to look at the convention and maybe the committee, it can go both ways, right? There's very positive aspects in this case, but they're similarly saying, although the states in the Sachi case were a bit more randomly selected, I would say, they can still also say, that case was inadmissible and we're using the same legal reasoning in this particular case. So my guess is, but maybe we'll get to this. There's also other cases in front of the European Court, but this will probably be inadmissible, I would say, although I of course hope for a different outcome. Yeah.
Right. So there is an admissibility issue because of, let's say, the causation between the claimants and the behavior of all of the states, right? And also because we don't know what the court will say regarding this issue of urgency. So let's sort of maybe take a step back, because in some countries these lawsuits have been successful, right? So if you look at Urgenda here in the Netherlands, Neubauer and other cases, national courts seem to be pretty progressive and ready to at least consider these cases seriously, even at the merits stage, if anything, right? And even if they're thrown out, at least you get to the merits. Whereas here we're talking about, okay, probably this is the furthest that they will be going. We don't know that yet, right? Because we've only had the hearing on admissibility. Now, do you think that the claims that are being brought could be brought at the national level? Do you think that these claimants or this group could have gone to national courts first? From a strategic point of view, what would have been the prospects of that happening?
Naturally they can go to the domestic courts, because in most of these states there are legal, they have a legal basis to bring climate litigation. I think the difference is that can of course take a long time, and we know that the specific issue of climate change is a cross-border issue. It's not just one of the domestic states. So then, for the European Court it will be more competency, that's not the word, but probably what I mean, issue that they're saying, we can't take this case because of our particular function. That can of course be a powerful argument there that a lot of the states are also making. But one advantage that this case will already have, and which I think is why it is important that it has been brought, is that all of the states were asked to respond, right? And so even if we look, for example, at the Dutch context with the Urgenda case, we've had that case, but the state has not implemented the judgment. So then Urgenda I don't know the status of this, but started a case through like financial fines sort of for the government. That's not the right word either. But they started a case to say, okay, you have to implement this particular judgment. Now the Dutch government is actually relying in their defense on the Urgenda case. It will probably, state what they're doing, how great they are at tackling climate change, and all of these things can also similarly be used still for domestic litigation, even if it doesn't go there. But of course, it will be much more a sort of direct approach if they do go into the merit stage, I would say.
Yeah, I would just like to add to that, because this is also brought by young people. And one of the interesting points that they argued was that because they are young, they have a dependency status. So even if they go to all 33 states, it's going to be quite a task for them. So it's also it's a lot strategic that they go directly to the European Court, because, litigating 33 cases before 33 courts and then waiting for it to go on appeal, and then that takes a lot of time. And as children, you really need to, make sure that you go fast, because you don't want to see the effects of climate change on the long term.
And access to justice for children in domestic contexts are very different. Because some, you have to have a guardian. You can't always, as a child, you're more constrained in your access to justice as well.
That is interesting. So you have mentioned this again, the intergenerational equity principle, that this is young claimants that we have before the court. Do you maybe know anything more about this principle of intergenerational equity, and how will that have to be proven before the court?
So the principle of intergenerational equity is quite important in international environmental law, and it's been it's found in many international environmental law treaties. And in this case, it's quite important because you have 6 young people, and they are the ones who are really facing or are going to face the effects of climate change in the future. So this principle basically tries to ensure that the natural resources that we have are preserved, so that they can enjoy the benefits. and it's kind of quite essential in climate change because they are the ones who are going to live longer and have to face the consequences. So it's also a duty upon the states to protect their rights, their right to freedom of life, and so it's important. So in climate change cases, it does make sense when it's filed by the youth that they did rely on this principle.
Yeah, I think a lot of the time when people are talking about climate change here, we've got a 2030 benchmark, then in 2050 we're going to do this, and 2100, and I think for a lot of people that are a bit older, they're just like, it's already a hard to grasp issue, because we know it's sort of happening, but you can't probably see it. It's more like an intellectual exercise than anything else in a way. But children, of course, in all likelihood, they're still here. And that's also the point that they're making with the ill treatment part, right? This is an important, I think that argument is so interesting from an intergenerational perspective, because that is so unique for the youth, that they know, all of these horrible scenarios that are being painted that are on the news of what will happen in 2050 if we stay on the current trajectory. They're still here. I mean, I will still be here, hopefully. But for the youth, this is a specific point which is very daunting, and
Thank you. I think the discussion of these environmental principles, which we're moving into right now, is really interesting because it bridges us into the substance of the claims. And of course, the merits have not been sort of reached yet in the litigation, but I wanted to ask you both, maybe before we start to wrap this up, to what extent are the claimants using environmental law or environmental protection principles and the science? You've already started talking about this a little bit. You mentioned the principles of precaution, mitigation, right? And so how are these related to the claims? Is there a very close sort of tracking of the substantial claims of the articles that you cited, Jolein, in the beginning, and matching them to these environmental principles, or are these really discussed separately? How did the strategy of the claimants evolve, or how was it presented when it comes to the interaction between environmental law and human rights law?
Well, very big question in a way, but I think there is a large reliance specifically on the Paris Agreement. So what you see is the Paris Agreement, I mean, all states have said through nationally determined contributions, this is what we'll reduce, these are our plans, and of course many states, and then this is the problem with climate change, they won't do it. So you're also very much subjected to the political whims of countries. If there's like elections, things might change, etc., etc. And the UNFCCC itself and the Paris Agreement, they have a compliance committee, but this doesn't have any binding force, which is why a lot of people turn to human rights law as well. Of course, it's a human rights problem, so there's an obvious link there. But an added advantage there is that it's legally binding. So you see that a lot of these environmental principles, and particularly newer instruments, tend to be soft law or not binding and have enforcement issues. They are being brought into the human rights realm. So there is a lot of reliance on that, and also similarly, of course, on science. There's larger issues at the UN as well about the need to fully incorporate and put some weight on science, and in this specific case, climate science, which is rapidly evolving and can tell us so much about what we're facing, and therefore must be taken, I mean, generally it must be taken seriously, but specifically when we're talking about climate change, we need to rely on the science. So there's definitely the emphasis is definitely on these environmental principles and science.
Yeah, I think it's pretty clear. And especially the science, they even though they file a case, against 33 states, and they do rely on the CAT, which is the Climate Action Tracker, right? Yeah, and that's also quite interesting because many climate change cases do rely on that, which gives you a detailed analysis of, how the country is doing with regard to its climate obligations. So they, in one para of the application, they do mention that there is an advancement of science, so you can see how a country is doing with regard to its climate obligation. So even though, there is a question of admissibility, if the court does go into merits, it'll be interesting to see how the court deals with the aspect of science.
Yeah, and I think that's also going to play, that's very interesting. Yeah. That's also going to play into evidence, right? And how the court, if it goes into the merits, weighs the science. And I think that will be a fascinating discussion within the court, but also within the community that is following the case. So I think that, this is going to be a very, very important takeaway. Eva?
Maybe then to just wrap up, there are other pending climate litigation cases before the European Court of Human Rights, such as the Karem case or the Klimasignorinen. And do you see maybe any differences or similarities between the two and their success in the future?
I see a lot of differences per se. First of all, because this is filed by 6 young people, and also there's the prayer, or what they're asking the court to do, is quite ambitious. Where it involves all 33 states, and they want the states to, have more ambitious targets and to reduce emissions. And also, if the court goes into merits then and issues a judgment in whatever direction, it'll be binding on all 33 states. Whereas the other climate cases are very domestic and are very state specific. So I think I see it more from the difference side. But maybe you can.
Of course. I mean, as we have mentioned on several occasions, it's a very unique case. So, of course, naturally, it's very different. I expect one of the cases to go into merits, and I expect it to be Klimasignorinen, because they have exhausted the domestic remedies. It's actually sort of like strangely the contrast, because these are elderly women that brought this specific case. But for their, I think it can similarly have like a very important ripple effect, because they're also looking at Article 6, the right to fair trial, because in the Swiss courts, they effectively said, you're no different than the general population. And this is a very important aspect of climate change, is that this is the argument that's being consistently made. Everything related to climate change is, in essence, public interest litigation, but that's just the nature of climate change. Should we therefore just leave it and just be like, what if we can't do that because we once wrote this down and this is how we're going about it? But their specific case is elderly women, so you still have this group that is particularly marginalized. They have exhausted their domestic remedies, and part of their argument is that in climate litigation, particular vulnerabilities, so for them to being both women and elderly, should be taken into account, and gives them a position that is actually victim status, which is where a lot of the discussions are going. So this is, in a way, will for youth cases more widely, then that same argument can be used as well, right? So even though it's not as effective because it's just vis-a-vis Switzerland, you always have precedents working. So if this case gets through to the merits stage, and I actually think that all climate cases, merits-wise, if the science is taken seriously, and I think it will be, specifically the European court, I would expect that there is a lot of chance merits-wise of cases succeeding. So hopefully at least one of the cases, preferably all of them, but the Karem case is a bit of a strange one, will go through and will have a bit of a ripple effect when it comes to climate litigation.
Great. Thank you for those responses. I have a follow-up question, because it seems that the people who are presenting the case, not just the claimants, but also the organizations that are supporting them, are trying to get a judgment that is a sort of a lawmaking judgment, right? Anmol, you just said that this would be binding on all of the states, and that this would be like almost a mini treaty, but it's a judgment in the courts. So this is a question for you, Anmol, since you do a PhD on judicial policy making. Is this the right place for that to happen? Or is it okay for this judgment to be a sort of benchmark for all of the climate obligations in Europe? And of course, you should feel free to jump in on this, Jolein, as well. And should we also not think of legislation, EU directives? And so how do you see, first of all, that role that the judges, we got our lights off. We need to move.
Oh, okay.
There we go. Sorry about that.
Too still.
It's a new system.
Okay.
We don't understand it yet. So, right. So, are the courts the right place for this decision-making process, or how do you see this playing out with, the EU Parliament or the national legislatures of the EU member states?
Yeah, I think this is a really good question, because even I'm conflicted as to whether courts are right place for this. But we also need to understand that people are coming to the courts because there is inaction by the states, and even if it's collective or individual action. And so the courts are, as an institution, do play a role in how we see, or how we ought to see, or how we ought to interpret law. So some people might argue that this is a violation of separation of powers, but the very fact that courts interpret the law itself is, a form of policy or lawmaking. So it's interesting that, that people are now forced to come to the court because there is inaction by the state. But on the other hand, the lawmaking process that happens with the executive or the legislature or the European Parliament is quite different from how we see lawmaking or judicial interpretation before the courts. Because with regard to the former institutions, you have public hearings, you have expert analysis, you have, feedback, and you have the whole process of lawmaking. Whereas courts, they are more closed, and they mainly, look at the parties' arguments and also amicus curiae briefs, just, if there are amicus curiae briefs, which in this case there are 8. But that still is not, a thorough lawmaking process. But I think it's also important that courts have come into this whole climate change case. But also they need to be a bit careful on how or what judgment or what law they make, because it will in the end have macro consequences which they may not have considered. It's amicus curiae briefs can help in a certain way for the courts to understand their macro consequences, but they should also be some sort of reflection by the court on the societal consequences that will come up.
Great, thank you, Jolein. Would you like to jump in?
I think I would agree. If we're talking a bit more sort of dark side of this judgment, what you can, for example, see, because we're talking about global problem and we're now just specifically looking at Europe, there's no surprise that then we're looking at mitigation. That makes absolute sense, but we're in this judgment, and if there would be reparations, we probably, for example, won't look at implementation, and there is a lot possible for states also abroad and in global south countries. And so there can also be a lot of negative consequences and new litigation popping up by doing such a top-down approach instead of a more bottom-up approach. So you have to very carefully monitor that, because if giving an example in the Paris Agreement, you can mitigate your emissions very simply put by implementing a project in another country, and which you see a lot, and which harms indigenous communities a lot. So those already marginalized, then they will start cases against this specific project, and this will all delay climate action too, right? So, and usually they're not even successful, even though this is a whole different issue, but of course they also have a lot of solutions for us, and they have a more balanced way of living with nature. So if we're saying, okay, we have to urgently, every state here has to do that, but you're not keeping an eye on the specific context, and it will just go rogue. That can also be a very global north, global south issue, which we should be very, very careful about. So I think that is an aspect to also take into account with cases like these.
Absolutely. I think it's really important to highlight the limits of these cases as well, not just the opportunities. And I think that the issues that you've both raised in terms of the position of the judiciary, its relationship to other branches of government, but also this north-south divide that could be probably even more emphasized, right, if we're not careful. I think that's really, really good to keep in mind as a possible dark sides of this kind of actions. But I don't want to end on a dark note. let me give you both the opportunity to make some final comment, some final remark before we close today's session.
I mean, so on a more positive side, I think it is very brave and amazing that these cases are being brought and by young people, and I think what you see is sometimes, their engagement is more tokenistic. I think this is a very strong push for taking the youth seriously in all kinds of processes. I think the fact that it was fast-tracked, that states have had to respond, means that we have a lot to move forward with either way, and I sincerely hope one of the cases will go to merits, and I think in the merit stage that is just a very strong case to be made, so hopefully at a minimum one will succeed.
Thank you, Jolein. Anmol?
So just building on that, it's also quite motivating to see young people, using the courts to, hold states accountable. And if any of these cases succeed, there'll also be sort of, a shift where, then states have to then regulate, industries and technology. And then there's also a chance for the science to develop, which is developing every day. And it also shows that courts can become an institution for social change. We're going to look forward to what comes out of this case. Thank you.
Great. Thank you, Anmol. Thank you, Jolein. Ava, thank you so much.
Thank you.
We're gonna keep in touch in order to follow up on this case. Maybe once the merits have gone through, you can come back, tell us about them. Yeah, great. Thank you so much for coming. Thank you for watching. This is Human Rights Now, our new video series for the Netherlands Network for Human Rights Research, and this is our first session. So hope you enjoyed it, and see you next time.